do the argument.
I'm conscious of, my lord, the time constraint. I must indicate, my lord, what I am going to argue. I am going to argue, my lord, one point with regard to the historical details, which has not come in, my lord, so far. The list of dates which was given, which is manifesto of 1944. I am going to say something about, my lord, 370. And then, my lord, about the governor's, my lord, proclamation and the presidential order. That's how, my lord. And I know I am not going to repeat. And I am conscious, my lord, because in Bhopal case, when I appeared before Justice Kaul, he said you have to summarize. So I am trained, my lord. I am trained in
now
that.
10 minutes, please summarize the point.
10 minutes I can, my lord. But
We have to wrap up by 4 o'clock.
my lord,
Everybody has time until 4 o'clock.
This is what happens. Somebody who is, my lord, sensible, then he is put into this difficulty.
Everybody is, Mr. Parikh. We'll now wrap up. Just formulate it. Just tell us.
I'll do my best.
Just formulate it. We'll take it down. Yes.
I am going, my lord. Now, the first point is, my lord, the historical details, which is, my lord, the manifesto of 1944, which is important.
Why don't you formulate?
My lord, I am appearing in repetition number. Lordship will just note 1368 of 2019. And my written submissions are from page 504 in volume 1 of the submissions. Now, my lord, the formulation is like this, that, my lord, the people of Kashmir on 29th-30th of September 1944 came together and gave themselves, my lord, a manifesto. In manifesto, they said two things we want. We want a constitution for for Kashmir, and then also an economic plan for Kashmir. Now, these two things were there. Then they went into the question of, my lord, what rights should be given to the children, what rights should be given to the women, what kind of land reform should be there. All that was part of manifesto. Now they gave it to my lord, to the Raja at that time, and then Maharaja. And Maharaja, for consideration that this is what we demand, and this is the democratic setup we want in Kashmir. Now, this particular manifesto, which, my lord, is taken as a Magna Carta, virtually, and that's what, my lord, Justice Anand says in his book on Constitution, was then accepted in the Constitution, and whatever people said ultimately in the manifesto, most of it, my lord, was included in the Constitution. This is known as, my lord, the new Kashmir, they call this manifesto. Now, the importance is this, my lord, that the sovereignty rests with the people, and they express, my lord, their sovereignty in a particular way. This is what they want. This is kind of democratic setup they want. Now, this sovereignty was, my lord, accepted when the Constituent Assembly was sitting and was translated, my lord, ultimately into the Constitution of Jammu and Kashmir. So there are two things, my lord, which emanate from it. Number one is that the sovereignty which vests with the people, and they, my lord, expressed it, and that expression was translated ultimately, my lord, into the Constitution which they gave unto themselves. That's number one. Second is, my lord, when there is a written Constitution, then that written Constitution is supreme. Now, Lordship, sir, my lord, noted the judgment in Article 143, that privilege case, my lord. I'll just give the citation and the para number, which says, my lord, that ultimately in a democratic country having written Constitution, it is the Constitution which is supreme and sovereign. That is, my lord, 1965, 1 SCR 414, and it is in volume 17, PDF. It starts at 337 at 357, para 40. Para 103. Note that in my submissions, because it has not come Now, my lord, the second judgment which I just wanted to draw your lordship's attention is my lord Bhumai's case, which has been cited before lordships. It is para.
So what's the, if you can conceptualize it, Mr.
The conception, my lord, that's what I'm saying. I'm saying that this, my lord, the entire idea, people said they want to have a democratic setup. And therefore they came together, gave themselves, my lord, a manifesto. Manifesto was translation of their wishes or desires, that it should be in a particular way. That, my lord, was given to Maharaja at that particular point of time, that please accept it because we want this monarchy to end, we want a democracy to come. So this expression, my lord, which was given in the manifesto, was translated ultimately, because as I said, it was a Magna Carta, and in the discussion also we find
that the Kant is in your
lordship,
submission.
So therefore the idea is
that Parikh, we look at your submission.
I know lordship said formulated. So it's, my lord, ultimately the sovereignty which vests in the people, ultimately transferred, my lord, in the constitution. As I said, the constitution is supreme and sovereign. My lord, that's the idea. And I, my lord, refer to the two paragraphs. One is, my lord, in the 1965 judgment, which is para 40, and para 102 and 103. So Justice Sawant's, my lord, view in Bhumai, and if your lordships permit me, I'll read only para 103, and this particular part will end. In this connection, may I give, my lord, your lordship the PDF?
No, we got it, yes.
Yes. This will be PDF 171, 172 of Case Law, Volume 2. 272? 271, 272. Now 102. Now 102, my lord. At 271.
Yes.
Now the lordships may skip, my lord, the earlier para, last 3-4 lines. It is true to say that democracy, people are sovereign. All powers belong primarily to people. The retention of such power by the people and the
these are well.
Lordships. Now, my lord, 103 is how the states are formed on the basis of linguistic, ethnic, and other things,
yes.
And that cannot be disturbed.
Yes.
Lordships were noted. That's enough, my lord, for me. Now, the only thing is, my lord, that in the book, Justice Anand, my lord, says that as far as the sovereignty is concerned and autonomy, they are, my lord, interchangeable terms, that what you call sovereignty is autonomy. Now, that is, my lord, something which is important when we say whether there is autonomy. Autonomy in the form of sovereignty, sovereignty with the people, and ultimately in the Constitution of Jammu and Kashmir. Now, my lord, with regard to the interpretation of 370, lordships have read it number of times. I just wish to point out, my lord, two things. One is, my lord, when we look at 371B and, my lord, 370D first proviso. These, my lord, two provisions, they talk about the consultation. Rest is concurrence. So my argument is, my lord, as far as the concurrence is concerned because the Constituent Assembly doesn't exist. And I must point out, my lord, how the Constituent Assembly of Jammu and Kashmir, because that has not been pointed out, how it was dissolved. There was a resolution, and pursuant to the resolution, it was dissolved. So therefore, my lord, those parts are concerned. The provisions, my lord, in terms of the 1954 presidential order, which has been issued, my lord, I know lordships are probably, if I'm repeating something, then 1954 presidential order, which is there. If you look at the 6 presidential orders which have been issued, the first one is, my lord, consultation. There are other 3 consultation. One is, my lord, CO 44, which is, my lord, under 373, where, my lord, the Constituent Assembly's prior recommendation was taken because they changed the explanation there from, my lord, Maharaja to Sadr-e-Riyasat. So that is, my lord, one thing which shows that ultimately you require prior recommendation of the Constituent Assembly. The only provision is 1954, which talks about the concurrence. My submission is, my lord, that the concurrence ultimately comes to an end because the Constituent Assembly is not there. But the question arises, my lord, which your lordships may put to me, what about the presidential orders which have been issued subsequently? The only answer, my lord, which I think can be given is that all the subsequent presidential orders which have been issued are either some changes, some amendments in the 1954 presidential order. They are not, my lord, because the areas were carved where the union will legislate and the areas, my lord, where the Kashmir, Jammu and Kashmir constitution will prevail. Therefore, my lord, all those things which have been issued can be justified only on this basis that these presidential orders, because 1954 presidential order was issued after, my lord, the concurrence of the Constituent Assembly or approval of the Constituent Assembly of Jammu and Kashmir. Therefore, the subsequent presidential orders which are issued were under the presumption that the Constituent Assembly's approval already exists as far as the presidential. This is one way to look at it, because when I tried to find out, I couldn't get any answer, because if the Constituent Assembly comes to an end, naturally the entire, there is no Constituent Assembly, therefore there can't be any concurrence in that sense, which is provided, my lord, under 370. I have formulated, my lord, 370. I just read, my lord, two formulations. 370, I am reading that, my lord. Provided the constitutional mechanism by which the instrument of accession was integrated into the Constitution of India. Recognized, semicolon, recognized areas where the Constitution of India will operate, and by respecting will of the people, carved out the areas where the Constitution they wish to give unto themselves will prevail. Second is, 370 is temporary in the sense that it contained the principles which would govern the formation of Indian Constitution as applicable to J&K as well as the Constitution of J&K. Once that was achieved, the aim and object of 370 was fulfilled. Seeing each other, meeting each other was converted into a relationship on mutually decided terms. It is this relationship which is permanent. This relationship could not be unilaterally altered. It is like a constitutional promise embedded in will of the people. With the dissolution of Constituent Assembly of J&K achieving its purpose of giving birth to the Constitution, the temporary provision achieved the permanent result. The other significant permanent feature being that people of J&K accepted J&K with all its territorial limits to be an integral part of India for all times to come. No, my lord, there are three documents, my lord, on the basis of which the interpretation of 370 is possible. One is, my lord, the Constituent Assembly debates in India, the Constituent Assembly debates of J&K, and the judgment in Premnath Kaul. Now, from all these three documents, my lord, two situations emerge. One is that the Constituent Assembly will have a final say. All, my lord, the debates as well as debate in Jammu and Kashmir and, my lord, the Premnath Kaul judgment says so. That number one, Constituent Assembly will have a final say, and number two is relationship will be finally determined by J&K Constituent Assembly. These are the two factors which are common, my lord, in the entire thing. I just wish, my lord, because the Mr. Gopal Subramaniam had read, my lord, the debates in Jammu and Kashmir Constituent Assembly, but I just wish to draw your lordship's attention to my submissions 504, just, my lord, look at 512.
Yes.
These are my submissions, my lord, which is in volume 1 of the submissions, starts from 504. Just kindly come to 512.
Yes.
And then, my lord, lordship may skip. This is, my lord, what Sheikh Mohammed Abdullah makes a statement on 370. The entire paragraph is that. Lordship may skip that and come to, my lord, 514. Just above para 26. The Constitution of Indian Union therefore clearly envisaged the convening of a Constituent Assembly for Jammu and Kashmir state, which would be finally competent to determine ultimate position of the state in respect of the sphere of its succession, which would be incorporated as in the shape of permanent provisions in the Constitution. This briefly is the position which Constitution of India has accorded towards. Now, this was, my lord, the same thing which you find in the debates, my lord, Gopal Swami Iyengar. He says the same thing we find, my lord, in the judgment of Kaul. And this is what. So there was, my lord, ad item as to what should be the shape and what should govern the relationship between, my lord, Jammu and Kashmir and India. Now, my lord, 26 is, which has not been shown to your lordships, how the ultimately it was dissolved, the Constituent Assembly of Jammu and Kashmir. Now, my lord, this is the statement which was made by Mir Qasim. He said, my lord, whereas the Constituent Assembly came into being for framing the constitution for the state, whereas the Constituent Assembly has enacted and adopted the constitution for the state, now therefore this assembly resolves, shall stand dissolved on 26th day of January 1957, which is the date of commencement of the constitution. Sir, I would like to make a brief submission with regard to this resolution. The resolution aims at dissolving the Constituent Assembly by passing and adopting the constitution, which will come into force on 26 January. The Assembly has done its primary and main function, and it is but natural that it would stand dissolved. Legally, it could not have been dissolved by any authority because people elected this Assembly for a specific object. Now, the object having been achieved, it is reasonable to dissolve it by way of a resolution. Hence the resolution. This Assembly is not capable of protecting the Constitution. It had only the mandate of framing and enacting the Constitution for the state and nothing more. Now we can skip the entire thing, my lord. And finally, on the next page, the last 4 or 5 lines, Mr. President, the question is whether the Constituent Assembly came into being for framing the Constitution of the state, whereas the Constituent Assembly has enacted, they adopted the Constitution. Now, therefore, this Assembly resolves, it should stand dissolved on 26 January, which is the date of commencement of the Constitution. And we close the business. And then, my lord, after this cross is, my lord, the proceedings on 26th of January 1957. Mr. President, today this historic session ends. With this, the Constituent Assembly is dissolved according to the resolution passed on 17th November 1956. Clock struck 12 p.m. and Constituent Assembly was dissolved by the President according to the resolution adopted on 17th November. I thought I must draw your lordship's attention to this important part, how it was dissolved. Now, my lord, as I have read, my lord, on 370, I am not going into, my lord, the Sampath Prakash and other arguments which I am skipping because all that has been argued. Now, lordships may only look at one part. 2 parts actually. The presidential order, my lord, which was passed on in 1954, had expressly, my lord, excluded articles 356, 357, and 360. Kindly look at, my lord, lordships have seen that, aware of that. That is volume 3, page 18. Now, these were expressly excluded, and because they were excluded, it was with the understanding that as far as there is a breakdown of constitutional machinery in Jammu and Kashmir, then ultimately it will be taken care of under the Constitution of Jammu and Kashmir, and they brought in Section 92 for that particular purpose. Now, thereafter, my lord, and this was with the concurrence, which, my lord, my argument, if it is accepted, then after that, no change was possible because 92 had already come into operation, which took care of the entire situation. Now, 356 was brought in by virtue of CO 71 in 1965. Now, lordships from market, this is page 37 if you lordships want to see volume 3. Now, 357 was not adopted. 357 was not brought into. It is only 356. So one question which arises is, we have to, my lord, question that what is the implication ultimately of 357 not being there? I hope I am clear, my lord. If your lordships want to note down the pages, I can.
Yes.
No. My lord, that 54 presidential order, just show me that. Yes, what I am trying to, my lord, point out is this, that the Constituent Assembly of Jammu and Kashmir,
At that time,
finally,
356
when
was
the
not-
finally the
356 was
situation.
not- 356 was not there. Subsequently, 356 has been made applicable.
No, my lord, what I am trying to say is, I can show the debates. When 92 was inserted, section 92, what were the debates, my lord, in the Constituent Assembly of Jammu and Kashmir? What I am trying to show is the Constituent Assembly of Jammu and Kashmir ultimately approved that 356, 357, 360 will not be there. And therefore, my lord, 92 came into being. So 92 provided for the situation because 92, equivalent of 92 doesn't exist for as far as other states are concerned. Thereafter, my lord, the changes were made, and in 1965, 356 was inserted, brought in. Said wherever constitution is mentioned, you read it as Constitution of Jammu and Kashmir. 357 was not brought in. Now, if you look, my lord, read 356, it says that you give parliament ultimately or to the president. Under 357 alone, that the orders can be passed or law can be made. Kindly look at 357, my lord. This will also have a bearing on, my lord, section 3, but I am not going to those parts. Now, 357 says, whereby a proclamation issued under clause 1 of article 356, it has been declared that power of the legislature of the state shall be exercisable by or under the authority of parliament. It shall be competent for the parliament to confer on president the power of legislature to make laws, authorize the president to delegate, subject to such conditions as he may think fit, for parliament or the president in whom such powers are vested to make laws conferring powers for imposing duties. I'll take your lordships, my lord, through the governor's proclamation 92.
Article 357 has not been made applicable.
It has not been made applicable.
And therefore, though Parliament can assume to itself the power of the state legislature to enact laws,
Yes,
you cannot further delegate it to the president.
correct. You cannot do that. That's not my argument. And kindly, my lord, see the proclamation which was issued on 20th of June 2018. Just look at that, my lord. That proclamation, my lord, is at volume 3, page 85. I am saying, my lord, that there is a machinery which existed to take care of the constitutional breakdown. And I am quoting again Justice Anand's book because he says, relying upon number of judgments which are given by Milord the Jammu and Kashmir High Court, whether it is, we can reconcile both. And the argument is, yes, we can reconcile. But the question is, ultimately 92 acts in a particular sphere and 356 acts in a different sphere altogether. You can reconcile, it can exist. But the question is, they operate in different fields. And once you exercise power under 92, and you say we are dissolving, and look at, Milord, this particular proclamation, which is, Milord, at page 85. Just look at it, Milord, in 92. And I'm asking myself why 356 was not issued initially. It could have been done. Why they resorted to 92? An answer will also come, Milord. Answer is because after the proclamation, on the next date, he dissolves, Milord, the assembly by resorting to section 53(2)(b), which could not have been done without the aid and advice of the council of ministers. Why it was done, Milord? Because it is dissolved, and then you take over ultimately. Now, proclamation, Milord, says powers conferred by 92, enabling me on that behalf with the concurrence of the. Now, one important factor I must mention. I am so sorry, I have to hurry up, Milord, otherwise necessary for me to show, but because lordships are aware, I am going on that basis. Section 92 says, Milord, concurrence of the president. So naturally, when this proclamation was issued, there was proclamation, it says so. There is a proclamation of President of India. Now he gives, Milord, the concurrence to the proclamation which was issued, the president. And after that, Milord, certain provisions are suspended. He says any reference to state constitution or acts or made by the legislature shall be construed as including reference or acts made by me. That is on page, Milord, para 5. In exercise of powers of legislature of the state under the proclamation made under such and such. So assumes, Milord, on that date itself, the powers to make the laws. Now, Milord, look at this one and 357. How you reconcile both the things. And next day, Milord, he says power vested upon me under 92(1), exercise of powers under 53(2)(b) of the Constitution, Jammu, I hereby dissolve the Legislative Assembly. Now, section 53(2)(b), if we read, Milord, section, I think 35, that this can be done. 92 you can exercise without the aid and advice of the Council of Ministers, but 53 you cannot do, which is necessary. So he does, Milord, a thing which is absolutely unconstitutional act. It was impermissible to do it. My argument here is, if you lordships, Milord, I can give certain, there's a discussion by Justice Anand in his book about how these two provisions can work in Kashmir. That is volume 17, PDF, Milord, at 143, 144. What is it? So, Milord, my submission is, in this situation, it was not permissible for the President, Milord, to invoke the powers under 356 because under 92, and 92 is something which was approved ultimately by the Constitution of India and also the Constitution of Jammu and Kashmir. It's a malafide, excess of power, and a fraud, which, Milord, I don't want to go into the judgments. Now, Milord, my probably last, I must say, argument is with regard to CO 272 and 273. Just kindly have a look at, and the argument will be very brief. Kindly look at, Milord, 272 at page, I think, PDF 101. Lordship had put a question to Mr. Sibal. This is 5th of August 2019. And 6th, my lord, is the final order which has been issued, CO 273. I must say, my lord, before I go to 272, is that 273 assumes, my lord, the fact that the prior recommendation of Constituent Assembly is necessary. If we understand that way, my lord, then kindly look at it. It means if you want to make any change in 370 as such, which we draw, my lord, from CO 44, which I pointed out, where you change the explanation. That's the only thing, my lord, which the Constituent Assembly approved. Now, here, my lord, what they do is that through the interpretation clause provision, they, my lord, indirectly change 370 itself. Kindly look at, my lord, this one. To 367 shall be added the following clauses. Lordships may skip A. A says construed as references to such and such. B is references to person for the time being recognized by President recommendation of Assembly. Sadar Riyasat, acting on advice of Council of Ministers of State for the time being in office, shall be construed as references to Jammu and Kashmir. Now, exactly the same words which are used in the explanation. So they are changing, my lord, the explanation without the prior recommendation of Constituent Assembly. And look at, my lord, below that. In proviso D, 3 of 370, expression Constituent Assembly of State 2 shall be read as Legislative Assembly of the State. Now, my lord, I ask myself that how this is possible that you can change 370 as such by virtue of the interpretation when you recognized in the very next order which was issued that Constituent Assembly's prior recommendation is necessary. So this interpretation, my lordships are asked, why this interpretation? Without this interpretation also something was possible. This interpretation was resorted to because they wanted to show the exercise ultimately done by them by CO 273 is something which is constitutional in nature. That is to say that they have done this thing after prior recommendation of the Constituent Assembly. So how they may not achieved it, they changed 370 to the interpretation clause. Absolutely, my lord, unconstitutional act. And after doing this, I hope I am clear, my lord. After doing this, then, my lord, the final order is given. What it says, CO 273. In exercise of powers conferred by clause 3 of 370, read with clause 1 of 370 of the Constitution, the President, on recommendation of Parliament. So, my lord, the recommendation of the Constituent Assembly after that was substituted by recommendation of Parliament. Is pleased to declare as from the such and such all clauses of the 370 shall cease to operate. So what they do is they know without Constituent Assembly they cannot do. Constituent Assembly is not there. They bring in through the interpretation indirectly. And my submission is what you cannot do directly, you cannot do indirectly. That's again a fraud on the Constitution. Lordships have followed, my lord.
This argument has been raised.
It was, I am so sorry, because I think I was attending all the, in this, because Lordships have put a question to Mr. Sibal, what's the meaning of this interpretation clause? Why they resorted to interpretation? They resorted to interpretation because they could not have done directly with 370. Therefore, they resorted to, and after making change, came out, my lord, with this one, on the recommendation of Parliament. Now, other question, which is a prior recommendation. According to 373, it is prior recommendation of Constituent Assembly, it has to be prior recommendation. Now, kindly look at, on 5th of August, this notification is issued. How, my lord, next day, a prior recommendation of Parliament was sought. On the face of it, my lord, it looks obvious that this is something, my lord, which is not permissible. The entire exercise, my lord, shows that it is malafide in nature. So therefore, my lord, this goes, 272 goes, the other, my lord, proclamations which are issued, they also go.
Thank you, Mr. Parikh. Thank you.
My lord, it becomes very difficult sometimes because I know, because you read a lot, chip by chip, my lord, things are removed. Few chips remain, my lord, then you have to sustain yourself on those chips. So probably I do not have done whatever is
Thank you,
possible.
Mr. Parikh. Mr. Sen.